Good afternoon, students. This will be our video lecture on two chapters, chapters 6 and 7. Chapter 6 was interrogations and confessions, and we're going to begin with that. When we look at the subject of interrogation and confessions, realize that we're in the realm now of looking how the Constitution looks at specific evidence that is developed from individuals. And out of all the forms of evidence, there is none that is more dramatic and powerful than a confession. Those confessions are reached in some cases through relatively little effort when people confess under a voluntary basis. But in many cases, confessions are only obtained after a lot of work by individual detectives and agents who use a variety of strategies and in a constitutional manner are able to engender incriminating information from individuals who have committed crimes. When we look at this subject, let's begin by realizing that there are basically three phases in the development of criminal cases. And I brought this up in a previous lecture, but again, you have to keep this in mind when you're trying to analyze examination questions. The first phase is the voluntary investigative phase where you are engaged in questioning of individuals on a non-custodial basis. So it's no custody, voluntary, but trying to obtain some type of information. During that particular phase, the only possible issue that would arise could be a due process issue. That information, a confession, for example, or damaging admissions that are obtained during that time, they're going to be admissible. Of course, even though it was a voluntary encounter, if certain techniques were used, that could possibly raise the issue of, it could raise a due process issue. But I mean, that's a little bit far, that's a little bit on the extreme level, but that's really the only type of attack that's normally made on an encounter that does not involve any custody. The second phase of the investigative process involves custodial interrogations. Now, this is the area that engenders the majority of the constitutional law involving confession cases. The third phase involves the area of the criminal justice process that moves from the investigative phase where the detectives are running their case and finally the charges have been brought and it has entered the prosecutive stage where the prosecutor and the judge become the major forces, and a Sixth Amendment right has become attached. That means that the predominant issue is the right to counsel in regard to any type of interrogations. So we have the three phases, and they all engender different they engender different areas of interest involving different amendments of the Constitution. Now, if a confession is obtained at any phase, you should examine that. Now, this entails a question. If you're given a confession question on an exam, once you see that it is a confession, realize you're going to have to look at that in basically kind of a 5-step process, because there are different requirements that are important as to the admissibility, the Constitution, and the constitutional nature of a confession. Now, the first one is, of course, due process. Due process, and again, we're going to look at due process a little more as we go on here. But right, due process, 14th or 5th Amendment, involving essentially, in most cases, these are procedural due process issues where how was it obtained? How was the confession obtained? Did it in fact involve fairness? Was it done in such a manner that it would not shock the conscience of a court? That's the first consideration, and it applies to all three of the developmental phases of a criminal case. The next issue is Fourth Amendment issues. Was the confession obtained during or as a result of some type of Fourth Amendment activity, a search, temporary seizure, a full seizure, an arrest, and was the confession connected to the Fourth Amendment issue? In fact, and was the confession in fact, was it in some cases caused by, would not have taken place without the Fourth Amendment operation? The next is, and this is a very minor consideration, is what used to be called, which still is called McNabb-Mallory rule, but although today this is not very important, we're going to touch on this briefly. But the McNabb-Mallory essentially is a Supreme Court rule, and it has been limited by congressional action as to the effectiveness of how its influence over the confession issues. The next is the Miranda requirements of the Fifth Amendment. The Fifth Amendment issue and Miranda. And lastly, we have the Sixth Amendment right to counsel. So these are the things that you should be examining as to whether or not the requirements of these basic 5 areas have been met. If they haven't been, if any one of these areas have not been met, that confession will not be deemed to be constitutional if challenged, and it goes before, even if it's admitted, or I mean, it could be suppressed at the hearing, at the suppression hearing, if it was successful and later on somehow a confession was obtained and it went through the court proceedings and a conviction and it went up to the Supreme Court. These are the areas that the court would examine in regard to the confession issue. Again, if it was found to be that they did not meet constitutional muster, then that confession would be found to be unconstitutional, and it would certainly cause that case to be sent back. And if at the suppression hearing, it would mean that confession would not be introduced into evidence. Okay, so we got the 5 steps, the 5 areas you have to look at. We have the 3 phases of the investigation. All right, now let's look at these specifically. When we look at the due process issue, what we're really looking at is whether or not the confession was voluntary. And that's why even at the early stage of a voluntary encounter, there could be things that might happen that would cause a confession to be considered involuntary, even if there was no requirement for example, Miranda warnings. Voluntariness is basically a 2-part test. The first thing we look at is whether or not the agent of the government applied some coercive techniques trying to force this information out, and whether or not that the subject or the defendant or the suspect, his will was overborne, and that a reasonable person in the place of that individual, that their will would be overborne. The main factor is that in confession cases, if there's any type of physical violence applied to somebody to obtain a confession, that confession will be involuntary as a matter of law. Now, non-physical coercion is not involuntary as a matter of law. That is going to depend on the totality of the circumstances of the confession, in which the courts look at the personality, the disposition of the individual who gave the confession. They look at the techniques used, the method of the interrogation by the agent or the agent of the government, and they also look at the environment in which the confession took place. Where did it take place? What were the restrictions? Were the restrictions placed upon the individual confessed? The techniques used, definitely the areas in which this becomes really tricky is when tricks are used, or there are tricks. Lies are not per se unconstitutional. These are techniques that are pretty widely used, often quite successfully. Again, it depends on whether or not a reasonable person would have their will overborne before those techniques will be considered to be unconstitutional. The threats, however, or promises of lenient treatment almost have the same, basically almost the same status as physical force. Not the same exactly, but it's close. If a threat is made, or if a promise for lenient treatment is made, that you're going to receive lenient treatment if you confess. The court, once that's ascertained to be correct, that's suppressed. That confession is going to be suppressed. But other things, even information as far as saying that, for example, a common trick often applied is that that your co-defendant has already said that you committed a crime, or we just have a report here, we found your prints at the crime scene, or your DNA was present on some of the physical evidence we had, even though none of these things were actually true. That will not make a confession illegal. Again, it has to go through the process. If this was someone, for example, who had a severe mental disability, that probably would make that confession unconstitutional. If that type of technique was applied at the same time that someone had not been allowed to have anything to eat or drink for 12 hours, or not to go to the bathroom, or needed some type of medication and they weren't allowed to take it, and you're also using these techniques, that could make a huge difference and could cause a confession to be unconstitutional. But tricks and deception, standing alone, the use of those will not make that confession illegal. So look very closely. If you're looking at an exam question and you see that's been used, those techniques have been used, that doesn't mean that confession is illegal. But again, you look very closely at the characteristics of the person who confessed. That can make a difference. Number one other factor, when we talk about the initial incident that leads to the confession, and that's often, in almost all cases, that's going to be an arrest. At that phase, what a defense attorney would do would be to look at the arrest itself. If they can find that there was not the proper standard of proof was not met before that individual was arrested, or if a warrant was required and it wasn't used, and that the confession was causally connected to the unconstitutional violation of their Fourth Amendment right, then that confession, under a doctrine often called the fruit of the poisonous tree, will not be admitted, will be considered unconstitutional. Now, again, how do you determine this? It's totality of the circumstances. And I would say that in most cases, if the confession is remote from an unconstitutional violation, to where it's often said that the taint has dissipated, then the confession can come in. For example, unconstitutional seizure, confession is obtained, or a confession is not obtained, unconstitutional seizure's been made, you realize it, decide that you're not going to obtain a confession at that time, you wait for a significant period of time, you approach the individual again, you try to get a confession, or they've had a chance to talk to an attorney, and their approach, they waive their rights, you get a confession. The fact that there was an initial unconstitutional seizure would probably be dissipated. But it is something to look at. An exam question again, the seizure, temporary or a full arrest, if you didn't have a reasonable suspicion for the seizure or probable cause for the arrest, and the confession took place, it was causally connected, that confession will be unconstitutional. McNabb-Mallory rule. McNabb-Mallory rule is a rule of procedure that the court set down. Basically said that, well, we know that both state and federal governments have rules regarding after the arrest that an individual has to be taken to see a magistrate. You know, that's normally the arraignment, or in some jurisdiction they'll call that the preliminary hearing. But that to be arraigned initially, where they're going to be advised of their rights. The phrase that's usually used in most statutes is without unnecessary delay. The Supreme Court in the McNabb-Mallory in their rule of procedure, they wanted that to be done, you know, really fairly quickly. Well, there was a law enacted by the Congress that basically said that you have at least 6 hours to where it's not even a consideration. After 6 hours, whether or not that delay in taking someone before a magistrate is an issue in determining whether or not the confession is voluntary. It doesn't mean it's not per se involuntary, but it is on a totality of the circumstances, a delay after the initial 6-hour window. Then you have your delay, then that can be examined by the court to determine whether or not that was unnecessary. States have various procedures. In general, most states are, I would say, more lenient, although this may be changing, a little more lenient in how they look at the delay in taking someone before a magistrate. The next factor to look at is the Miranda requirement, and now we're into an area that has two phases. One, was the individual Mirandized? Well, first, was it necessary? For example, you've made a temporary seizure of someone on the street. You're questioning them about, about why they're there, trying to get an ID, and during the conversation, during the temporary detention, all of a sudden that individual starts to talk, and you start questioning him. Example, did you commit a crime? Are you intending to commit a crime? And they admit it. You haven't Mirandized him. Not necessary. He wasn't in custody. Miranda requires two things. It requires custody and interrogation. An arrest, that is custodial, but an arrest is not always synonymous with a custodial situation. You may believe that someone is not, that it's not an arrest situation, but the facts and circumstances, if they cause a reasonable person in the same position as your suspect to believe that they are in custody, which means that they can't leave, they're under your control, and that it's not of a temporary nature, but of a nature that's up to the person who's actually put them in custody, then that means that Miranda, and you question them, then Miranda had to be administered before you questioned them. Now remember that you can be in custody, and if you're not being interrogated, and anything that a defendant, or if you, for example, have been put in a custodial situation, anything you offer up without questioning could be used against you. But if the law enforcement officer is going to question someone, they're going to have, and they're in custody, they have to advise them of their rights under the Miranda case. And remember, the two big issues here in the Miranda rights are, one, they have the right to be silent, and that right stems from the Fifth Amendment. And the other right that they have is a right to an attorney, which stems from the Sixth Amendment. It's also been integrated kind of into the Fifth Amendment procedures, that as being a necessary requirement of that situation. If we move past this, past the warning, the Miranda warning, the custodial situation, now the interrogation procedures itself. You can ask, and in an exam question, there are questions you can ask that will not violate the requirements under the Constitution for an interrogation. You can ask booking questions. Where are you from? How tall are you? Well, those are not guilt-seeking questions. Interrogation these are questions that you're attempting to obtain information that is related to the crime that you're investigating. It is guilt-seeking information. It is not routine questions that are unrelated to an individual's guilt. It's administrative type questions. They do not require that you be Mirandized to do that. The waiver, Miranda, before someone can be questioned, can be interrogated, they have to waive their rights. That waiver has to be knowing and voluntary. And again, the Supreme Court there's a lot of individual situations as to what a waiver entails. Generally, it has to be specific. Someone does not have to, for example, be told that, for example, if someone asks you, should we see an attorney? Or I think I need an attorney. Well, that is not, you don't have to tell them, for example, you do need an attorney. And if they seem at all uncertain, and this is just a probing question, you can continue questioning them. The Supreme Court's been consistent on the idea that you're not on the nebulous questions about whether or not there should be an attorney. But once someone says, I want an attorney, or I need an attorney, then all questioning must cease. When we look at another area that involves interrogation, involves the Sixth Amendment also. This is when someone has the prosecutive stage has begun. Normally, at the arraignment, at the earliest stage, at the arraignment, a preliminary hearing, it can happen after grand jury indictment, warrant has been issued. Once that happens, it's a different ballgame. No longer is interrogation based upon the idea of custody. Now the operative phrase is elicitation. You can't elicitate guilt-seeking information from somebody about the criminal case they've been charged with unless they have waived their rights. Because they do have the right to an attorney, and that's what this issue is about in the Sixth Amendment. They don't have to be in custody. This can be any type of normal conversation. If you start to elicit information about the case they've been charged with without them waiving their rights, then at that point, that becomes an unconstitutional violation if that individual should confess. Some other areas where Miranda is not necessary. Remember this, questioning people at the scene, Miranda is not required. Temporary detention is not required. Grand jury statements. Threat to public safety. If you feel that there's a public safety threat, that someone, that you need to question somebody now, even though that you put them in custody and you need to get information because you believe there's a threat to the public safety, at that stage you can interrogate them and gain guilt-seeking information without Mirandizing that individual. It's called the public safety exception. Classic case involves someone who basically had left a gun in a store, and the police knew that and asked them about where the gun was before they Mirandized him. They were able to obtain the weapon, and they were able to use that at trial against the individual. All right, we're getting close to winding this up for Chapter 6. And let me give you a typical question, and so you can kind of see how you feel about how the questions will read. Now, I'm going to read the question now. Subsequent to a defendant's arraignment. Subsequent to a defendant's arraignment on murder charges, the police planted an informant in the same cell with him with instructions not to solicit information but only to listen. In due course, the defendant, without any prompting, told Benny Lee, and that's the Benny Lee, that he and two other men had committed the murder. So Benny Lee, the informant, has now been told, without any prompting, that by the defendant that he and two other men had committed, the guy, he confessed, he and two other men had committed the murder. Will that confession be admissible at trial? You know, subsequent to arraignment on murder charges, police plan an informant only to listen, not to solicit information. Will that confession be admissible at trial? Think about that. What is it, yes or no? Well, yes, it will be admissible at trial. Basically because it was before the arraignment, the Sixth Amendment right had not attached, he was not in custody. There was no law enforcement presence there, so he did not have to be Mirandized, so that confession will stand. That's it for Chapter 6, and our next tape will be on Chapter 7, and I hope this helps.